Okay, I now came back. So pleased to see you again. So I said that this system is quite exploitative. Now I'm a first-time user of this technology. Quite in some cases for the challenges actually, and in other cases I need help from tech fixers and something. Thank you. So the topic that in this will be basic. As you know, the basics of legal research would be the course often delivered far earlier in first year law school, and the library staffs and professors would introduce. So actually they are junior professional, and quite a fair share need to be also available for them, since it's 3 years training and legal education condensed to make them exposed to the basics of laws and legal research method, how to search the cases or authorities, and they may run they may manage a student-run law reviews. So they would be an important part to collaborate in some sense. In that context, they appeal and also training to get fast learn about legal system and many basic dealings. Well, a lifetime which must be on lifetime impact through their professions, careers, and so for the class of American legal system, it would be one way I inquire myself to let you to the basis of legal research, and we would be more practical to have some experience in the actual setting about the public website for legal research. So what the Westlaw is actually on paid basis. So I'm not sure if it could be a free public access. We have some other domain of business, quite diverse about sources, and this illustration would be perhaps most representative, I suppose. Oops. It fails to lead me to the website, so another point in chaos. When I conducted in PowerPoint file, it led me to the website. Oops, it did not work. Let's see. Then what's the way to I'll consult my assistants later. And actually the visual presentation would be effective, I suppose, on the website. So I may process how to type the keywords. For example, in the first website, I may type a low burst. Wait, it led me to the case summary, main holdings, and aftermath, and also led to the PDF version, as I said. In my preparation, I was introduced to Florida, the website of state of Florida, and you would see some sections about concerns and interests of public. The judicial branch would be located. So a destination you need to go to look up for cases and others. In earlier day, I was led to the district Court of Appeal in the state of Florida, and they posted a recent court decision, what called State versus Vinci. It was appealed to District Court of Florida, District Appeal in Florida State, and the code named as district. The titular put district, but nonetheless it is an appellate code. Florida is a larger state, perhaps three of larger states, California, Texas, and Florida. And the case loads of code is tremendous, actually. So they need to create an immediate appellate code, and the legislature would not be responsive to the needs of judiciary. Some important politician would actually successfully lobby to create a district Court of Appeal in Florida. And now we have five district Court of Appeal in Florida, which is intermediate court, and functions as in to be responsible for appellate. And we have one state Supreme Court, of course, and the other state would be California, perhaps. They have a state appellate court, and their initiative is same with Florida. They initially has a title with the word district. Then it's actually confusing. The appellate court, why we call a district as district? Often illustrating the federal jurisdiction, kind of lower court, and a different name to denote appellate responsibility. So the California dropped that titular word, a district. So now they have Court of Appeal in that state. Nonetheless, Florida state still uses that name to denote appellate court in the state. So it is a state court, although we have a title district. So do not make yourself confused with a federal district court. We have about over 90 district courts, according to the geographical terms, you know. And the first 14th Court of Appeal, as a matter of federal jurisdiction, circuit court, and also special matter jurisdiction for each district in the federal court. In this case, the District Court of Appeal is a state judiciary. And the case I was referred to about my class preparation is titled State versus Vinci. It involves a suppression of evidence for constitutional reasons. So, you know, such a notorious rule about probable cause. So the police search and seizure need to be based on probable cause. Otherwise, the evidence collected during the search and seizure would be suppressed by that. So it's admissible to incriminate the suspect actually as a matter of law. And that issue was debated in that court. Of course, the state court may develop to transfer to the federal jurisdiction if the parties would dispute as a matter of federal law. So we have two sources, two grounds of federal jurisdiction, which makes the federal court competent to deal with the case of controversy. Diverse jurisdiction, you know, and also subject matter jurisdiction. So, in this case, the circumstances would come to play. For example, the light is well lit, the car is well lit, and also no clear indication about the driving is quite tracing, for example, or they will not keep on this lane or her departure through the lanes. So the police has due cause to stop the car and ask for basic inquiry about the safety and the kind of way. So the state case law also confirmed in that context about many lawful action or competencies for police officers, so public safety and other healthy traffic condition on the road, public highway. In that case, one passenger also mentioned about gun in the car, the driver's pocket in the car, and they exchanges communication and spend time about search and seizure, and actually illegal contraband, pills without prescription was found, and there was kept the pills would be turned to be found illegal as a matter of state law if the passenger drivers would hold without prescription. And that context was embroiled whether the police has acted in due course of pertinent law, the enforcement to seize the illegal contraband would be lawful, and the evidence collected would be admissible as a matter of state laws. So, and the court would, of course, invoked many auxiliaries, actually binding laws in common law system, and present quite a persuasive logic about legal reasoning, you see. So actually the lower court decision was overruled, and the evidence was adjudicated to be admissible. So a valid ground to subject him culpable in terms of criminal law kind of context. And I also plan to introduce to some public university website, or in purpose of exposing you to LexisNexis search. It is also useful. For example, I have picked up the case named Lubin versus Coors Brewing Company. In order to locate the case, I simply put the case name, and 763 sources will retrieve, which are books, articles, cases, and other secondary sources. Among them, 2 or 4 instance cases, which means the case name appears with the number of cases. The case we pursue would be 1, and other cases would be related with citations and other ways. So we have some massive number of cases which would be hard to handle. So we may have some another information to narrow our scope. In the process, we finally destined to the case name in full is Robert E. Rubin, Secretary of Treasury, and petitioner in this case, and Coors Brewing Company. It was a Supreme Court case which was argued November 13th, 1994, and decided April 19th, 1995. The citation for this case would be officially 514 U.S.467, and we also have another official number of citation, 115 SCT 1585. In this case, SCT means the Supreme Court, of course. And other a secondary nature of citation and informal citation would be offered in the case of LexisNexis website. I'm not sure if this is practiced the same in Westlaw. Even 95 Daily Journal DAR 4920 was indicated as one form of citation. This wide coverage of citation information seems distinct in my conjecture. I initially intended on the coverage of I initially intended on the Find Law database, but failed to locate the case. We have another website, Cornell University LII, so Legal Information Institute, seems to cover more extensively than Find Law. However, the case name led me to tremendous amount more or extensively than Find Law. However, the case name it seems effectively working, since the classification was based on the area of subject issues, such as federal rules of civil procedure, federal rules of evidence, Supreme Court rules. I visited this section of Supreme Court cases since I already noted this is Spring code. Nonetheless, it could not make me more convenient to a small scope of retrieve cases. I also used time of decision and part name. So the strengths and weaknesses are in span in my result. So you will have no definite nature which defines each public website as attribute, as kind of attribute. The citation for this case was provided clearly. Rubin, the Secretary of the Treasury versus Gooseberry Company, 514UU-S 476, and 1995 in parentheses. And the date of decision also available, 19 April 1995. It is noted the other form of citation was not available in this case. So you may practice this. For example, you will have a citation without a case name. Then can you make you any faster and other experience could be found? Actually the citation or the virtual same in my case. So I simply type the number of case, or what you call citation, and it led to the jumble of documents numbered around 800. Case of love-free 300, which requires additional work to locate case. Within the result group, I found that Virginia appellate cause came to matter in 25 instances. So in parentheses, we have additional information, VA-CT-APP-2003. This means the decision was rendered by Supreme Court of Virginia, Appellate Court of Virginia, and decided in 2003. So in LexisNexis, you will be available of a classification in response with respective jurisdiction, Supreme Court cases or state cases from Virginia, for example, state cases from Texas or Florida, California, New York, and others. So among 300 cases, we now will be narrowed down to 25 instances. So you're now be glad to locate the case. The case name for the citation was Jackson vs. Commonwealth. The FindLaw.com website also responded with no results of find when I simply typed the citation. What does it mean? No results find. So actually, FindLaw is Nassaro about case law, and also many abbreviations in presentation of cases, and also you will find a summary, which is not the weakness actually, since we have some gist of information which ready about specific cases. So it is one way to deal about a summary of a brief of case, and link the brief to the PDF version. So eventually you will be available of whole content of a court opinion. This allows me to use the Cornell Law Information Institute to search the case. So fine law would be on default. The website led me to the State Court portal of Virginia, which compelled me to search by citation. It turned not to provide a case with only one case in retrievable archive. The Cornell Legal Information Institute website was also returned a tremendous amount of documents which contribute to massive difficulty for their specific case. So in this experience, I may state that the commercial commercial providers of legal information would often more working, and the source is precious to facilitate the legal research. But in some cases, you'll find as contrary. So that is not an absolute statement. So depending on the situation, so choose your bigger to apply any alternatives if you are faced with a difficulty. In one tip of advice, you may reduce key terms if you are pressed with a press of cases retrieved, for example. In other cases, you will expand the key terms in. For example, we often prefer to use 2 or 3 key terms. May use 6 or 7 terms that would generally effect to retrieve a small number of cases if we expand it. That, however, would not be absolutely true. In some cases, the reduction of a key terms in number would help out. And actually, we will not be subsidized by pay basis commercial commercial providers. Nonetheless, we'll have some basic information when you undertake a journey of a sea of cases, for example, Westlaw analysis. In search of case law databases, we may make it work on several ways of access. As I said, the first way to begin with would be to use the number of cases officially assigned by the government and case reporters. For example, we may enter 433-F3D237. In this case, we need to know the citation for case and could use the volume number reporter abbreviation, or F30 would be a reporter abbreviation, and page number in correct blue book or ARWD citation form, or some recognized facsimile of the correct forms. So simply type this number, and the lawyer case about reporter abbreviation would also work. So you did not mind between capital letters and lowercase f's d would be interchangeable in effect. Then you will be directed to the case name United States versus a Martha Stewart. And you will also apply the case name search. For example, simply type Nixon versus Fisher. You may have an experience about Westlaw. It could work as a key to locate that specific case. For other way, we can search the cases relevant with the issues and concerns by implementing the keyword search. As of nature, the first two cases would often be used in the situation where the research would be narrowed to the issues and research plan. The case name can be gleaned, as I commented, from the second source to serve its research purpose, which means the low-level articles may make them to be disposed in the initial phase of work. So you begin with your research. Reading the low-level articles. Then you'll have information about cases based on citation. This might be useful for many illegal researchers, but the caution also would be adequate for reasons. For instance, the low-level articles might not include all the useful cases of reference, which can prejudice your view and scholarly research work. In the search of case law, Westlaw provides a useful tool of research convenience by which we can refer to the same or similar point and its current status as a good law. So fairly computerized to make you systemic about your research. For example, citing references link could lead you to same or similar points by making you to the destination of a similar cases. And full history and direct history links could offer these services. So historically, the case law was dealt in this progress. In the wake of case history, you'll find its precision would diminish in some aspect of this. So is it still a good law? That question could be solved when you refer to this service. Westlaw also provides a link to the PDF version, which serves distinctive the user's need. Even the core briefs from the council can be traced for a reference. So fair in extent and scope, and actually we have kind of vivid materials about interchange of legal opinions or the argument, contention. Westlaw database is structured in orderly fashion, and extensive coverage is typical. So you need to train yourself to adapt with the abbreviations others. For example, all cases, what does it mean in capital letters? All fast. This would mean all federal case would be retrieved in your denomination when you type to search for the databases. All federal, what does it mean? We have a word, old, so it would be a federal case, perhaps antedated. And SCT, it would mean a Supreme Court decisions. All states, federal acts or many nominative capital letters to define the nature of that database. The keyword search would be primary, given the research often is not definite or narrow to specific case. And if you are an experienced researcher, you may come across the way about keyword search, what they call Boolean connectors or others. So what does space mean in your work on retrieval? The Boolean legal connectors will subsidize the experience of users. For example, you may need to phrase such queries in a number of words before or after. In this case, you can simply type dog-3byte, which will pull up any document where the word dog shows up 3 words ahead of or behind the word byte. So you now interested in keyword dog or byte. Perhaps talk cases about damaging others, but the owner of dog might be responsible about the biting others. So you now refer to the case on these words. In this case, 3 means 3 words, ahead or behind. You may simply type dog-byte. In this case, you will be led to more number of cases than this denominator context of typing. So what actually you will see is 3. The number 3 will be reasonable about your search purpose. We experience a multiplied example on this format. For example, a dog-s byte and dog-p byte, they respectively mean a sentence and paragraph. So it serves to define a search scope. So your alphabet typed in between key terms would actually be read by a computer device. So sentence and paragraph, the number 3. Then the computer wisely operated to serve your command. We also need to have a tip for expanders and alternative forms, such as a spec, asterisk, and exclamation point. What does exclamation point denominate to define the work of computers? Exclamation point. Plurals and possessive forms can be retrieved. When you type a singular form of words, unless unusual plurals, such as women and mice, are not picked up. So the computer make it legible between singular and plural form of words. Nonetheless, they would be stupid about unusual plurals. If you type woman in singular form, they fail to retrieve women or mice. In your due surmise, I suppose. The context would not be out of your expectation when you have an issue on acronyms, abbreviations, compound words, and phrases. You learn simply to practice as manual guys, and we could increase our skills if we practice putting all together of several queries. So, you are now very skillful about handling Westeros. Then you would be a competent user to putting all together over several queries. So you are now prepared to reduce key terms and also make them align with your research goals, and also some structure in the prospective pieces would be sketchy. So what? Actually, there are sources about legal database. What is LexisNexis? The Westlaw seems to work on a pay basis, so it would not be available in some universities. I'm not sure that is the case in Chosun University. So, if the research need to base their search on key terms, it would be alright to rely on the database name search, since the research work from adjacent sciences can be captured from the journals of humanity and social science. So you would be a patron of University Law Library, for example, then there would be a journals provided in the name of a social sciences or other interdisciplinary piece of research, which would also be a resource to enrich your research plan. Then please do not restrain yourself to a specific database. General approach with the key terms you are now in pursuit would serve good. While you expand your horizon of search, you can narrow your interest in adequate pieces using pertinent to your research goals. So don't be afraid, even though it will retrieve many pieces of research articles or other documents. Expand them as possible to widen your perspective. In the initial stage, also you need to make yourself narrow down to the final stage of research about. And often the process would occur in order. So second sources would be first instance, often attracted to your concern, and in progress you will know the need about a search of primary sources. Otherwise, you may be immediate to the LexisNexis if you intend on case name or citation search. The final outcome is one branch of Westlaw, which provides a less condensed service for the legal researchers. And as commented, this database is fairly open to public access, so most expedient point of reference in the case of research, legal research. The coverage and depth of service seem to fit in the interest of convenience, readiness, and possibly less intricate. It could be handy and serves the need of practitioner attorneys as theirs impressed. During your training, you may encounter kind of change of landscape in legal service. From the ads launched by FindLaw.com, a print media used to serve legal profession. Then what of them in this contemporary time? Use Westlaw to win a case and use FindLaw to win a client. It would be dubious if the information gleaned from this line of database could suffice the in-depth scholar way of research project. While considered the Cornell University website, I once found it convenient and very serving in the process of my legal research. So I may see them not constant. So please refine your search to meet a specific deals. Ad hoc basis about the convenience. It may be a comparable worth with FindLaw.com in terms of depth and width of legal information available to the researcher. And I also need to have some remark about actually challenging if we are not on the actual website. Visual way is very facilitating in test purpose. In some cases, you find cases using digest. When you're given a legal problem and you set off to use a digest to find cases that discuss this legal problem once again, the first thing to do is to break your problem down into catchwords, legal concepts, or brief phrases to summarize the legal issues implicated by your problem. The gateway to the digest is the indices. And the indices are organized into alphabetical lists of keywords, brief phrases, and legal concepts. For example, you are interested in hunter or hunting, weapon, rifle, gun, accident, accidental, negligent, negligence, injure, injury, trespass, trespassing, trespasser. So you have some sense in this illustration that the keyword search would not be limited to legal terms. In some aspect, the laywords would work more effectively to render you to the cases pertinent. Digests themselves are organized by catchwords, concepts, and short phrases. They present cases dealing with those catchwords, concepts, and phrases. The index to the digest, often called the descriptive word index list, and cross-references these and other related keywords, concepts, and short phrases. Even if you do not come up with the exact keyword from your problem, you often will find a cross-reference that leads you to the correct term. For example, gun will cross-reference you to weapons, dog will cross-reference you weapons, and dog will cross-reference you to animals. Hunting will cross-reference you to negligence, sports, and recreation. Another nice thing about digests is they are organized by region, national, regional, or state, or jurisdiction, federal versus state. or subject matter, bankruptcy, military law, so that you can more readily zero in on the best cases for your problem. So this way of structure, and this will define similarly in the Cornell University LII. So I advise you to locate the public website. It is open to public access. If you cannot find cases using the most promising words and concepts, broaden your inquiry into these other areas. Read all the hunting headnotes. Read further in the weapons, guns headnotes. Think of synonyms for initial words and concepts and search for them. So it is wise to repeat the search practice in a specific situation. It might be cumbersome in some aspect, but could refine yourself to final success. For example, in your textbook, you will see some illustration of the process using West Michigan Digest. And the comment was displayed. For example, weapons, descriptive word index. Don't forget to check out the pocket part in the back of Digest to find the most recent cases. A timeline of cases meaningful in the legal research, and I also introduced you system, history, direct history, others. West Digest and key number system. West is king of digest, just as is the king of case law. Common features of West Digest are, so please refer to your guidebook. Legal situations are divided into 7 major categories: persons, property, contract, torts, crimes, remedies, and government. Categories are subdivided into more than 415 topics, which are arranged in one alphabetical sequence and are numbered. For example, you will see constitutional law, number 92, 515. How do you agree this order and structure? Make sense? Each topic is subdivided in specific subtopics, words, concepts, phrases, and assigned a key number. This is written as topic, followed by the key symbol, followed by the key number. For example, the constitutional law may be divided into liberty to contract, or freedom of speech and of the press. So it respectively assigned the number 8, 9, or 89, 90. On West Law, the topic name is replaced by its number, and the key symbol is replaced by the letter K. These key numbers correspond to the same subtopic in every digest published by West. The subtopics in turn correspond to the headnotes you find at the beginning of every case published by West. If you find a good headnote in a case, you can get the key number of the headnote and go to any West Digest and look up at other potentially relevant cases that contain the same subtopic identified by the key number. Then, how do you find what topics and key numbers to look up? Common features of West's key number system used to find topics and key numbers and they have to find relevant cases, include a descriptive word index, so topic outlines analysis, table cases, dependent predictive tape, words and phrases, and popular name tables, key number, advanced pamphlet, and pocket powers, advanced shoes. So quite orderly in coherence, so useful, and also the nature of West Digest will be organized in general. For example, United States Supreme Court Digest, Federal Practice Digest, Regional Digest, State Digest, American Digest System, Century Edition Digest, Decennial Digest. So, for example, you will see an earlier date of case laws, which span between 1658 and 1896. Wow, 200 years. And the Decennial Digest in coverage between 1897 and 2001. General Digest is most updated. So 2001 through present and also in progress. And we have a specialized digest, other digest. So loose lip service and private reporting service, for example BNA, CSH, sometimes have digest to accompany the loose lip publications. American Law Reports, its own digest series. And also you will find cases using annotated law reports. Then what are annotations and annotated law reports, and how to use annotations. So American law reports, perhaps the granddaddy of them all. They are synonymous in some people's mind with annotated law reports, and this generalization is not that far from the truth. AR dominates the field of annotated law reports. That the abbreviation is the same for both is no accident. So practically in overlap, what actually for the reality of legal researchers, and function of ARS would need to be noted. So please take time briefly to have this introduction. Researching cases with ARs. So it's a familiar name, and of course gives you what basics of a court rulings. And please remind yourself of the limitations of ARs. Do not be seduced by the attractiveness of the AR or package. Some cautions would be adequate. There are certain things they AR do well, but there are several things they do not do. They do not answer the legal question, but organize relevant authority around and about the issue so that the researcher can efficiently investigate, analyze, and eventually draft the writing that answers the question at hand. They are not jurisdictional specific, so you have to sort through a lot of information to find relevant and controlling authorities from your jurisdiction, and you will probably have to do follow-up research based on the controlling and persistive authority you define. So may divert to you indirectly. They are now written like a proper office memorandum. They have an outline, but it is not the kind of outline that you should use to draft a proper office memorandum. ALRs are focused on narrow, specific legal issues, particularly those that are troublesome and unsettled, rather than on general catchwords, phrases, and keywords, key number concepts like West Digest. So there would be strengths and weaknesses depending on the databases. You also will have some point about verifying the accuracy of ALR, and also might have an issue how to update all the ALRs. So we have other issues in researching case law. For example, you also will have some awareness of a Shepard citations online. So it is traditional form of legal legal information service, and the Shepard's method is quite controlling of the DACS. It would be replaced in some extent. However, still what actually affect your rate of interaction in the process, and of course your work on research. So the rest of introduction would be for yours. I will make a brief comment in the next class. Okay, any question? Then I will now stop here and see you in the next class. Thank you for your attention.